Welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Jim Quillinan. He is an attorney and shareholder with Hopkins & Carley in San Jose, where he is the chairman of the Family Wealth and Tax Planning Department for California. He has been practicing law since he graduated with his law degree from the University of Santa Clara in 1974, only yesterday.
It's coming up on 40.
Darn. Jim is highly respected in the legal community and is a frequent lecturer and author for the State Bar of California and continuing education of the bar, serves as a special master and referee in Santa Clara County and San Mateo County Superior Courts in complex trust and probate matters. Jim loves to go to the movies.
Correct.
Every week. But 2 or 3 movies a week?
As many as 5.
Oh my gosh. He writes movie reviews, and they're very popular. You can sign up to get them by email for free at www.hopkinscarley.com. One of Jim's claims to fame is he managed to make a guest appearance on the David Letterman show many years ago. But anyway, I'm just thrilled to have him as a guest with me today because he has a lot of wisdom to share with us. Today, Jim and I will be discussing whether a family trust should be terminated considering tax law changes in the fiscal cliff tax legislation passed January 1st, 2013. It's called the American Taxpayer Relief Act of 2012. And so we'll be talking about also a little bit of its impact on estate planning. Folks, this is a complex subject, no doubt. So just an introduction to this area to help you to become aware of them for further discussion with an attorney or other tax advisor who's familiar with them. And to say that we're really familiar with them is a bit of a stretch. Anyway, the problems we're discussing are complex, and there may not even be solutions for them yet, folks. So but we just want you to be aware. Just an introduction to this. Jim, thanks so much for joining me today.
Oh, it's my pleasure, Mike. We'll see if we can make this a little more clearer than mud.
Okay. Well, I'm actually looking forward to this very much because this is sort of a hot area for estate planners. All right, well, let's just revisit a little bit of this. I'll just call it fiscal cliff tax legislation because that's what they would probably call it on the street. People sort of understand what that means. What are some that apply related to families and why they should possibly revisit their trusts?
Well, the major thing that changed was the estate tax and gift tax and generation skipping transfer tax exemption was increased. And currently it's at $5,250,000 per person, and it's indexed. Mm-hmm. So for a married couple, that's $10,500,000. Right. And as of about a month and a half or so ago, married couples is a lot more broadly defined than it used to be.
Okay.
So non-traditional couples, if they're married, are married now.
Okay.
And this applies to them too. And this exclusion, or it's not, the exemption applies for, as I mentioned, estate, gift, and generation skipping tax.
Right.
The gift tax exclusion that went up to $14,000 per donor, per donee per year. The other main change is that now the rate, there's a flat rate for every one of these taxes. It's 40% if you get into the range of having to pay tax. And of course, the other thing that happened, both state and federal income tax rates went up. Mm-hmm. That is so complex depending on married status, levels of income, what taxes apply, but it's the income tax situation has changed dramatically. Basically, income taxes have went up, especially for higher income earners. The state tax has gone up. Pardon me, not the estate tax. The income tax has gone up. The other component of it, and it seems very simple on its face, is what's called portability.
Right.
And that means that I have a $5,250,000 deduction. And if my wife has a very small estate, if she died, she could leave me her exemption. And so I now would have her exemption and my exemption. And so potentially I could have a $10 million exemption. So portability was designed to be sort of a simplified way to make sure husbands and wife, no matter whether it was community or separate or what it was, collectively have a $10,500,000 exemption. Sounds simple. In application, it can get very complicated. That's something individual people would have to talk to their planners and counselors about to make sure they understand how that might work. So, and then the other thing that happened, which has come in an interesting thing in our practice, is this fiscal cliff legislation also added this 3.8% tax on investment income to help support the healthcare legislation. So, and that pops up in trusts. Now, so you have trusts that have investment income. All of a sudden, a trust has this extra 3.8% surcharge or additional tax on investment income. And the thing that people forget about is that a trust is a tax-paying entity, but the exemption for a trust is only $11,950. And once you get over that, then you're at full income tax rates, which could state and federal blended. It's about 50%, possibly over 50%. So you don't want to have trust income taxed at the trust level. Strategy is get it out, get it out, get it out to the individuals, because the individuals have anywhere from $200,000 to $450,000, I think it is, for a married couple. They have a significantly greater exemption available to them. So getting income out of trust is an important thing. So all of these things have happened legislatively over the last year in a world that's been around for a long time, especially in my lifetime. At the beginning of my practice, the federal estate tax exemption was $80,000. For a long time, it was $600,000. And we're dealing with a lot of trusts and things out there that were designed to avoid estate tax that didn't work very well for income tax purposes, but the estate tax savings were huge, and so you didn't care about the income taxes. Now you have trusts that you don't need for estate tax purposes, but backfire for income tax purposes. And how do we fix those things? What do we do to make it work better? Because if we can somehow or other modify, revoke, change estate planning trusts that may have been in place for some period of time and make them work better for everybody under our current contemporary tax structure, how do we do that? Mm-hmm. And needless to say, we're doing a lot of this right now. It's becoming a major part of our practice, going back and looking at these things. We call them fix-it projects.
Right.
It's that simple. And how do we go about making these old trusts work better for families given our current contemporary tax situation?
Right.
Okay.
Now, related to some of these things, there is another area that we didn't touch base on. So let's just talk about it briefly, because it's another of the reasons why we're re-looking at trusts and whether we should continue with them and so forth. And that has to do with the basis adjustment.
Exactly. That's one of the that's actually, I didn't mention it yet, but that is the core reason we do this most of the time.
Okay, so maybe you can explain a little bit about.
Well, here's the situation. Let's just say way back, 10, 15 years ago, mom or dad died, you set up a traditional estate planning trust and you allocated the $600,000 exemption to it, and you put the family home in that trust. And at that time, that home in Mountain View was worth $600,000.
Okay.
It's now worth $2 million.
Yeah.
Okay? So what's happened is that basis got frozen at $600,000 when it comes out of that trust. So if I can somehow or other undo that trust and have the value of that home includable in the surviving spouse's estate, I will get a step up in basis. And I will now have a house with a $2 million basis when the second spouse dies. And if my total estate's under $5 million, I don't have to worry about estate tax. I've now got a house with a full step up in basis that doesn't have to pay any capital gains tax. Mm-hmm. The capital gains on $1.4 million, is
Well,
$400,000 or $500,000
Well, yeah.
at least.
And we got about 20% for the federal tax rate, and then we got that 3.8% investment tax that
Yeah.
we're talking about. So we got 23.8% federal tax plus California, whatever it is,
Yeah.
depending on the tax
Yeah,
status and so
it's
forth.
somewhere in the
So it's pretty high.
30%
Yeah,
range.
yeah.
So
So
I'm
it's
just
a lot.
ballparking, but
That's fine.
yeah. But that's the idea, is that you can now take that property. I've used the example of a piece of real estate. It could have been stock. It could have been all sorts of things.
Yeah.
But if we can, if we somehow or other can get it out of that trust and back in the survivor's estate, I can get a step up on the second death. And there's some other sort of practical issues that go along. If you have one of these tax planning, estate planning trusts, we call them bypass trusts. They require separate accounting. They have separate tax returns.
Right.
They have expenses associated with them. And so if you can get the family out from underneath those kinds of expenses, it can work better for them.
Okay. Now, you were talking about how trusts could be subject to tax, income taxes at a very low threshold, about $12,000. Suddenly, boom, you've got this huge tax that applies. So are trusts always taxed on their income?
Well, the way you'd figure out if there is any trust left in the income is basically you have the ability in a trust to make what's called a distribution deduction.
Yeah.
So if the trust has $100,000 worth of income and it's distributed out to the beneficiaries, the trust net income is zero. Okay, because the beneficiaries have to pick up the income tax consequences. But let's just take that same fact pattern, and for some reason you don't distribute it out, or you can't, for whatever reason, that $100,000 is stuck in the trust. It's going to get taxed at absolute maximum brackets, which is somewhere in the neighborhood of 50%. And I've actually done a lot of these things recently. If I can sprinkle that $100,000 out to, especially if they're young kids that are in college, I can reduce the tax cost to zero, because they're not going to have any tax. They're going to be below their exemption rates, and the tax cost will be next to nothing, if not zero.
Have to watch out for kitty tax and stuff.
Well, they're talking college age kids. Yeah, kitty tax is there if they're really young.
Yeah. They've raised those ages quite a bit.
I know they have now.
So, anyway, but it's important to be aware. And then also, there's some income, though, that it will be taxed to the trust, even if you make distributions. So, like if you have a capital gain, in most cases, that's going to be taxed to the trust.
Correct. Capital gains will be taxed to the trust, but that's pretty much the same.
Yeah.
One way or the other. And depending on how the trust is drafted, you can even draft a trust that capital gains will be passed out to the beneficiaries.
Yeah.
So these are just part of that contemplating the overall tax costs.
Yeah. Do you have to go to court to terminate a trust?
Not always. There are some circumstances you don't. I would say it varies. A lot of the time we do go to court to do it. There are two basic general rules. If the settlor, that's the person who creates the trust, is alive, and the trustee and all the beneficiaries consent, you can modify and terminate a trust by a writing.
No, it's the grantor, we said.
Grantor, settlor, settlor, all sorts of names, trustor, all that.
So the person who created the trust and the beneficiaries have to agree.
Yeah, and usually the trustee is, the code calls for the trustee, but the trustee is usually one of those people.
Okay, but the problem is after the grantor has died.
If the grantor has died, then the code says you must go to court on a petition to get it done. And once again, you have to have the consent of the trustee and the consent of the beneficiaries.
Okay.
There's even a couple of other code sections that deal with exceptionally low principal or changed circumstances where you can actually go to court. If you don't have everybody's agreement, you can still force a change or modification of a trust. But generally speaking, everyone's on board. And the truth of the matter is you want to do it with everybody's agreement. So.
Okay. Now, if all the assets of the trust are distributed to the life income beneficiary, do the remainder beneficiaries have to report a taxable gift?
It depends on how it's structured. Okay. because on the type of trust that we're doing. So if you have a life income beneficiary who terminates, it depends on how old they are, because it's their life income interest.
Yes.
So if they're 90, and you figure out what the factor is that their life income interest is worth, it's not worth much.
Yeah.
I just did one recently, and a 90-year-old woman, little over $1 million trust, and she's going to release her life income interest so that in essence the kids get the rest, the remainder interest. The value of her interest that she released is only $94,000 out of $1 million. That's the value of the gift, and that's completely covered by her $5 million exemption.
Right.
So that works very well. Another technique that we use is you sort of flip that around, and you can have the life income interest by the remainder. And this usually we do these in charitable trusts because the charity wants to have their money now and doesn't want to wait. So you have the life income interest by the charity, and if the life income people are young, the value of the remainder is low. And the charities would usually like to get their money now, and they can do it that way too. Okay. Because it's a charity, there is no tax problem then.
So you have to sort of do the figures, and the IRS has tables to figure what these percentages apply at different ages is based on life expectancy.
Yeah, and it gets more complicated, but you can have more than one life. So we use softwares, I think you know, to do all this very easily for us now to figure out what those values are.
Yeah.
And there's a couple of other sort of interesting variations out there because we see these a lot. There's something called a QPERT, or a Qualified Personal Residence Trust is what QPERT stands for. And this is it's actually in the code. It's a trust that's permitted specifically by the code, in which a person can put principal residence, up to 2 of them, reserve the right to live in it for a period of years, and at the end of the period of years, the property will go to the children. And depending on the ages and the term of years involved, the value of the gift can be pretty low as what goes to the children. And frequently people have done those, 10, 15 years ago when the exemptions were low. They don't need them now.
Yeah.
The other problem is if they stay in the house past the end of the term, they have to pay income. They have to pay rent, income to the kids.
Right.
And so they don't want it. And there's several different ways to do it. Usually everyone's alive. So you have the settlor alive, the trustee and the beneficiaries are alive, and they can just agree to terminate it. The other way, which is actually frequently the simplest way, is that the grantor has the right to live in the house, and if they don't pay rent, it self-destructs for tax purposes. So you'll get what you want. You'll get the house in the estate of the decedent, get the step-up in basis, and it passes to the kids. And they get to live in the house rent-free. So just don't pay the rent. It's a very simple way to do that, too. So.
Okay. Well, we've been talking about all this business of taxes and, maybe terminating a trust is desirable. Are there reasons to continue the trust?
Oh, absolutely. The trust does provide asset protection. And so if the beneficiaries of the trust have judgments or there's problems with them, you don't want to do these things because the trust will provide almost ironclad asset protection for the beneficiary. The other component of it, there's several other aspects of it, one of which is that this is all based on the fact that the exemptions, federal estate tax exemptions, staying at $5 million or going up.
Right.
It's possible they could come crashing down. Pretty unlikely, but if you have an exempt trust, it's exempt for all purposes. And so when I make it unexempt, I'm possibly exposing it to tax if the exemptions go down.
So what we're saying when we said exempt for all purposes, what we're talking about is, again, for estate tax.
For estate tax purposes, yeah, correct. And the other aspect of it, too, is that if a lot of the times people do these kinds of trusts because they want to control the disposition of the asset.
Right.
And if I undo it and I take this exempt bypass trust and I give all the assets back to the surviving spouse now owns them. and they can do whatever they want with them.
Mm-hmm.
The kids may not get it. That's why you have to have everybody on board, that they understand what they're doing.
Right. So this is like a second marriage situation, for example. Okay, and you want to assure that this is going to the children of the deceased spouse.
Sure.
If you take it out of this trust, it may not go to those people at all.
That's true. Yeah, I was going to mention the other technique that we use. This is pretty simple too, again, and that is if you have one of these exempt bypass trusts there for the benefit of the surviving spouse, they almost universally say that the principal can be invaded for the health, maintenance, education, and support of the surviving spouse.
Right.
And one of the other techniques that you can use, even though the settlor is now dead, you can have the trustee of the trust determine that the principal needs to be invaded under that standard, give notice to all the beneficiaries that they're going to invade the principal up to 100% for the benefit of the surviving spouse, and have the beneficiaries consent to that invasion. So you have a trustee invasion of the principal for the benefit of the surviving spouse. So you just move the assets out of the exempt trust to the surviving spouse.
Right. And in that particular case, there's no gift because it's under the terms of the trust.
That's right. That's not a gift at that juncture, because it's an exercise of a right by a trustee over the corpus.
Now, there are also some states that still have estate and inheritance taxes too, right?
Correct. And there are quite a few of them. And unfortunately, if in fact you have a state that has an inheritance tax, and I believe either Oregon or Washington or one of them do, I'm trying to think of some of the ones that are on the West Coast.
Yeah.
If you're going to do any of this, you have to go back and have that evaluated from a local state estate or inheritance tax point of view, to make sure, because that system is different than an estate tax. So
right.
it needs to be looked at.
And some families that have really large estates still could benefit from these trusts, right?
Oh, sure. I mean, we're not doing these for families that have significant assets. I mean, if their net worth is well over $10 million and they're doing, exhaustive estate planning, this is exactly what they don't want to do, because this is all predicated on the fact that we're going to change these trusts and there's going to be no estate or gift tax consequence.
Right.
Because they can fit within the available exemptions that are there for them.
Right. So, Jim, is this a do-it-yourself job?
Oh gosh, no. You really have to be careful on how you do this. I describe it as setting the stage. You want to make sure that you've documented, you've done it all right. There are times when you want to make sure you get a court order, even though you may not actually technically need to. But if you have a court order that makes findings of fact, those kinds of things can be binding on the IRS. So doing this the right way is very important. And when we do it, we always want to make sure that the family's CPAs involved looked at all the numbers, because we may not know everything as the lawyer, but the CPAs usually do, because they're seeing the annual tax returns, they're seeing everything that's going on. And make sure that everything's been analyzed and then disclosed. Disclosure is key, and then we do it.
Right. Now, there's one other thing, and that's that, well, folks, this can be an expensive process, because shouldn't each beneficiary probably have their own attorney when they're...
If it's a really significant one, yes. I mean, a lot of times not. It can be so obvious to everybody that it makes sense that they're willing to do it, but we always... if we're representing just one party in it, we always make sure that, that they know that we're only representing this party, not representing them, and they're free to get their own attorney. And having your own attorney is I think, a very good thing. I just literally before I came here today, just finished one, and I was very grateful that the lady who was giving up the interest was represented by independent counsel, because when that started, she wasn't. And she was giving up a very significant trust benefit, and she said she didn't need it, and the truth of the matter is she didn't. But I'm very glad that her attorney signed off.
Right. So we just have a a little bit of time left. Maybe you could throw out a final bit of wisdom related to this whole area.
Well, all I would say is that this new world that we're living in with these increased exemptions, you really need to go back and kind of revisit. Go back to your estate planning lawyer, go back to your CPA and see whether you really need these things. I get these questions quite a lot from clients now that have, our firm's been around a long time. They've done planning that could be, at this point, 20, 30 years old, and all of a sudden, the entire paradigm that we've been operating under for a long time doesn't work anymore. And we can adjust it. We can make it work. And some people think they're just stuck. And my admonition is, no, you're not stuck. But you got to get to somebody who knows how to do it.
Right. So it's a brave new world for estate planning. So there shouldn't be any unemployed estate planning attorneys, at least right now. Everybody was maybe a little worried with this huge exemption and so forth. But this is a great time for people to revisit these estate plans, to look again at these trusts, and think about, is this something we should really continue? You can pay me a couple $1,000s or more each year just to prepare the income tax returns for these trusts, and that adds up over time. So
correct, and you may not need it anymore.
You may not need it anymore. Folks, we hope we've given you some things to think about. This is a brave new world. You can see why I was excited about talking to Jim about this today, and hope that you'll benefit from this. We'll see you next time on Financial Insider Weekly.